All rise. First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, great state of Florida, and this honorable court.
Good morning. You may be seated. Okay. Good morning again. Welcome to the First District Court of Appeal. We have one case on the docket this morning. It is State of Florida versus Evan Hamilton. Counsel for the state, you may proceed when you're ready.
Thank you. Good morning, Sharon Traxler for the state, who was the prosecution below. I'd like to reserve 5 minutes for rebuttal.
So noted.
That's okay. We're here today on a set of facts that is tragic and incomplete. There was a boating crash, which the defendant, Hamilton, was operating impaired, and 4 people were ejected from the boat, and he ran over one victim with a propeller, and that victim died at the scene. Officers came and developed probable cause to arrest through the field sobriety exercises and asked the defendant, when there's a fatality, we have to draw blood. Are you willing to draw blood? And according to the record, the defendant, that was the first time hearing that his friend had died. So he was very emotional and said, "Not now," and was quite distraught during that period of time. So the officer backs off and goes and talks to the supervisor, or whoever was on scene, the investigator on scene. And after allowing the defendant to calm down, the second officer, Officer Johnston, went and asked him again, are you ready to do it now? At this point, Hamilton gets up, says yes, and walks off towards the ambulance, not the elevator, the ambulance. And the officer Officer Johnson, notices the father falling to the ground on his knees and stops and goes back, while Mr. Hamilton, the defendant, goes on to the ambulance and gives his blood draw.
Counsel, let me ask you this question. It seemed concerning to the trial court that the information that the officers relayed to Mr. Hamilton about the blood draw were not an accurate statement of the law, or misleading at best. Can you comment on that? Do you agree with that?
No, ma'am, I do not. Even given the facts as the trial court determined them to be, there was no error. There was nothing coercive. The officer did not mislead by an incorrect statement of law. It was a correct statement of law. It says that when probable cause has been developed, the officer shall get blood.
So the statements, we will draw blood from you one way or the other, we're going to take blood, Mr. Hamilton wasn't going to leave until we took blood, and of course no mention of the warrant option. Is that an accurate statement of the law?
It is. It's an active investigation. Probable cause had developed, and the officer was not going to allow Mr. Evans to leave until the investigation was complete. He could have arrested him, put him in the back of his patrol car, and left him there, drove him to the sheriff's office and done an interrogation there. But that's not what the officer did. They were very solicitous in trying to have Evans have time to calm down, and so that they can talk to him. They went back and forth.
So you agree that either a warrant was needed or valid consent?
Warrant or consent.
And so you're arguing that there was valid consent. What is the evidence for the...
Well, the fact that, the first time the officer asked him, he said no, or not now, depending on which version you want to go with. And so the officer walked away at that point and left him alone, left him time to calm down. So the second officer, when he went back, the not now is a completely ambiguous statement, you can take it as, no, come back later, or yeah, but come back later.
So was that the consent, the not now?
No, it was not a denial or a refusal. It was just, I can't deal with it now, I'm emotional, I can't deal with it now. The second time, when the officer went back to clarify, because the officer had been in touch with his lieutenant for a search warrant, and the lieutenant said, if you need a search warrant, we'll get a search warrant, it's not that big of a deal. That part was probably my addition. But the consent was when he said yes to the second officer's clarification and followed the ambulance, EMT to the ambulance.
So, counsel, when we have conflicts in the evidence, and evidence can be interpreted in different ways, as you know, we are to defer to the trial court's determination, and not only on credibility but weighing of the evidence. And so it sounds to me in part that your argument is asking us to reweigh the credibility determinations and the inferences from the evidence that the trial court made. And so tell me why I'm wrong about that.
Well, I'm not asking you to completely ignore the trial court's determination of the facts, because even accepting the facts, the statement to the family, whether it was to the father or to the son alone, it was accurate and non-coercive. It didn't mislead in any way. It wasn't as if he said, I'm going to get a warrant, when in fact he couldn't because he didn't have PC. No, he had PC. He could have gotten a warrant. It's not impossible in today's times, but it's consent or a warrant. And they had consent. And while the trial court in his writing, the order completely ignores the second officer's reapproaching and asking him again.
Well, is that where you mentioned earlier there are different versions of what happened, and is that where we have different versions of what happened according to the investigator? He couldn't remember exactly what he said. Looking at the record at 7-8, I can't remember exact words that I used, but it was to the effect of, are you ready to come give blood? That seems to be on the heels of saying, you must give blood. And so, I mean, my struggle is finding where was the consent given, and particularly given that the other version of the story seemed to come through the father, who said that all they got was, or that the conversation was along the lines of, you must give blood.
And I don't think the record was clear with whether the father was referring to the first officer or to the second officer. There was clearly two different officers asking approximately 30 minutes apart. One time when he just informing the defendant that his friend had died, and so they needed blood, and the other was the officer coming back 30 minutes later when he was calm. I don't know if the judge doesn't say, I don't believe the second officer came back 30 minutes later. He just didn't talk about that in his finding that the first time was a refusal, and that the statements to the defendant were coercive. And they're not. The cases that are on point in this situation talk about the officers it being coercive when the officer misleads or misinforms. And that's not what we have here. We have the officer.
Well, it has less coercive and more of a submission to authority. Basically, the officer is presenting, you must do this.
And then he comes back and
submits
says,
to authority, and so we can debate whether that's coercive or not, but
right.
It seems to be, whatever you call it, where is the valid consent?
Well, the valid consent in the state's opinion is when he said yes. And it was not as a result of a show of authority. And I say that because the defendant had already said, I can't do it right now, go away. So he knew he had the ability and was not under the impression that he had no choice here. You know, he could have said, I don't want to give blood now, I don't want you to have blood, but that's not what was said. He simply said, not now, and then yes, and that's the consent. So the trial court erred in two ways. One was it specifically finding that the not now was a outright refusal. There's no way that not now can be determined to be an outright refusal. Just simply the words do not mean no. They could easily be sure later, but not now is what was used. And the second thing is that the law enforcement statement was a correct statement of the law, and it was not misleading. He had probable cause to go ahead and arrest him if he had wanted to, but he was trying to be accommodating and allowing the young man to relax and get comforted by both his father and his girlfriend at the time. They both were there. They adjusted the air conditioning vents to blow away the gnats. The officer allowed the father to bring the bug spray, allowed time. He would back off and come back and redo the field sobriety exercises. So over the course of time, the young man was able to calm down. So the cases support the state's position that they had probable cause. No warrant was required, nor was they required to tell the defendant that we could have gotten a warrant. That would have been coercive.
What is the best case that we can look to?
I found the case of Dennis v. State, and it was one that dissented from, if I can find it, dissented from, or declined to extend, I'm not sure, from Powell. And it's 737 Southern 2nd, 47. It's a First District DCA in 1979. It's an old case. But it talks about how the Powell case is distinguishable from the facts in this case because in Powell, heavy demands were made, and once the contraband in Dennis was found in the back of the truck, they had probable cause, so therefore the officer's actions were appropriate. Whereas in Powell, they didn't have probable cause, and that's why the court found that the officer's actions of breaking the lock was coercive. So,
Counsel,
that's-
you're in your rebuttal time. You're welcome to continue or reserve the remaining time.
no, I'd like to reserve. Thank you.
Thank you.
May it please the court. Michael Ufferman on behalf of the appellee, Evan Hamilton, seated at appellee's table is co-counsel Tom Findley. Let me begin with the standard of review that applies in this case. It's clear that with the trial court's order on a motion to suppress, the court's review is a mixed question of law and fact. The court uses a two-step approach. The reviewing court defers to the trial court's findings of fact, provided they are supported by substantial evidence, and the court reviews the law de novo. However, the key issue in this case is consent and whether or not consent was voluntary. The state concedes that in its briefs. And the state also concedes that when there's an issue of consent, that's a question of fact to be determined by the totality of the circumstances. But if a trial court makes a conclusion of fact regarding whether or not consent was voluntary, this court must defer to that finding if it's supported by competent substantial evidence. The key competent substantial evidence that would support Judge Fleury's conclusion in this case is Dr. Hamilton's testimony. Let me just read a little bit of that. This is pages 96 through 98 of the record, which is pages 54 through 56 of the hearing transcript. So Dr. Hamilton explains that initially when law enforcement officials approached his son, they asked him if he would be willing to consent to a blood draw, and he said, not now. And then he says, and I'll start quoting, so 30 minutes later they came back to both of you, and Evan, yes, sir. And you were together with him, yes, sir. And what did they say? Florida statutes say that we need to have a blood draw. You need to come with me now and give your blood. Did they say that we will draw blood from you? Yes, we will draw, come with me now, we will draw blood from you. Let me stop right there because there's some discussion in the record as to whether or not Investigator Johnson was having this discussion with Dr. Hamilton, the father, or Mr. Hamilton, the defendant. Clearly, when Dr. Hamilton is saying that the words that were used are, we will draw blood from you, that's only referencing Mr. Hamilton, the defendant. Going on, okay, did they ever present you with a search warrant? No, sir. And when they were making these statements about the Florida statute requiring that he give blood, Evan heard the same thing? Yes, sir, he was next to me. Okay, did you ever see him deviate from his statement of not now? No, sir. Okay, and only after they took the blood they only took the blood after telling him that they will draw blood from you. Is that right? Yes, sir. That testimony that's in the suppression hearing clearly establishes substantial evidence to support Judge Fleury's conclusion that consent in this case was not voluntary. I respectfully disagree with my distinguished colleague on the other side about whether or not what was said to Mr. Hamilton was an accurate statement of the law. I submit that clearly after the U.S. Supreme Court's decisions in Birchfield and McNeely, that the Florida statute that would otherwise allow law enforcement to automatically take blood if there's evidence, probable cause that a death has occurred, has been overruled to the extent that the Fourth Amendment now controls, and the U.S. Supreme Court has clearly said that you can only draw blood if you get a warrant. There are exceptions to that, but during the suppression hearing, the parties discussed this, and the state specifically told Judge Fleury they're not relying upon any exceptions. No exigent circumstances would have supported what occurred in this case. They were only relying upon whether or not consent was voluntary. I would contrast what occurred in this case with what was said in the Miller case. The Miller case, obviously from this court, cited in the briefs, it's 250 Southern 3rd 144, a 2018 case. In Miller, this court explained what an officer is required to say in this context. It's almost an identical context. The defendant in that case argued on appeal that his consent was not voluntary, and this court went on to explain why the consent was in fact voluntary. And I'll quote, this is on page 145. The facts and circumstances in this case demonstrate that Miller freely and voluntarily consented to the blood withdrawal. Specifically, Simmons explained that refusal to consent would require him to get a warrant, for which probable cause existed, to obtain the blood sample, which he explained would require them to drive to a judge during the night to get the warrant signed. Simmons' explanation did not amount to coercion or misrepresentation of authority because he had probable cause and accurately described to Miller what would occur if a warrant were sought.
So your problem here is that the statement that was made was incomplete because it didn't talk about the warrant.
It did not. So the need for a warrant is clearly the law from the U.S. Supreme Court after McNeely and Birchfield. Telling someone that we're going to get your blood no matter what is basically telling him you have no right to refuse. He did have a right to refuse. If he refused, then they could seek a warrant, and that's what, when Miller uses the word accurately described, that would accurately describe the process. In this case, again, telling him in the statements that were used, it's right here. Florida law requires us to take blood. One way or another, we are going to take blood. That's 74 of the record. 76, he was not going to leave until we took blood. And in 96, we will draw blood from you. So there's no explanation that if you refuse, we will go through the process of trying to get a warrant.
So I mean, arguably one way to construe those statements is eventually they're going to take the blood, either it's through consent or the warrant. Granted, there is an omission, I think, in the statements by the officers, but if I understand the state's position correctly, they would submit that it's not inaccurate because ultimately the blood would be taken one way or the other.
Maybe. There's still, the whole point of McNeely and Birchfield is the warrant requirement under the Fourth Amendment is a judge gets to decide is there probable cause. So to tell someone no matter what we're going to get your blood, I think you have to say it just as was said in Miller. If you refuse, we will go through the warrant process and we will reach out to a judge and present the judge with what we believe is probable cause, and the judge will make a decision as to whether or not there is, and if he finds that there is, then there will be a warrant issued, and at that point we will definitely take your blood. But that's a key part of it, and the idea that you can refuse and take advantage of your Fourth Amendment rights. Judge Fleury cited to the Harrison case from the 10th Circuit talking about when is consent vitiated. This is what the 10th Circuit said in Harrison. This is Head Note 15, page 1279. However, government actions are coercive when they imply an individual has no right to refuse consent to search. They cite to the Bumper case from the U.S. Supreme Court. When a law enforcement officer claims authority to search a home under a warrant, he announces in effect that the occupant has no right to resist a search. The situation is instinct with coercion. Where there is coercion, there cannot be consent. That's exactly what Mr. Hamilton was told. You have no right to refuse. We are going to, Florida law requires us to take your blood one way or another. We're going to take the blood. We're not going to leave until we take your blood. We will draw blood from you. If they would have said what they said in Miller, if they would explain, you can refuse, but then we're going to engage in the warrant process, that would be, as the Miller court described, accurately explaining what the law is and what his rights are. But by simply telling him, we're going to take your blood, they did not accurately describe what the law was. They misled him. Any reasonable person in Mr. Hamilton's shoes would have took that to believe, why would I refuse at this point? I've already refused, but now you're telling me you're going to take it no matter what. He's only consenting because he's being told you have no choice. That's not what the law is. That's not what the U.S. Supreme Court said the law is.
Counsel, I want to ask you about an evidentiary point that was intriguing to me, and let me start by saying I understand your position is that the trial court did not need to rely on deposition testimony given the live testimony, but the trial court does cite to the deposition testimony in the motion to suppress, and your position is that's okay, even though it wasn't admitted into evidence, I don't believe, because it was attached to the motion to suppress. So how is it that deposition testimony that's not entered into evidence can be CSE to support factual findings?
If that's all there was, I would be in a different position. I cited to a case where a court referenced deposition testimony, but that's not my lead argument on this. My lead argument on this is if you look at page 121 of the record, which is the second page of the trial court's order, there's only 2 references to the deposition transcript, only 2. The first one is, and I'll quote, Investigator Johnson stated under oath, I told Evan Hamilton that the state requires us to take his blood. But he follows that up immediately with the defendant's father was also present for this discussion, hearing transcript, page 39. So he's backing up whatever was said in the deposition with evidence that came out during the suppression hearing from Dr. Hamilton. The next quote is, Investigator Johnson said we had to draw blood from him. We will draw blood from you. He only cites to deposition transcript page 13, but what I just read to you from Dr. Hamilton's testimony during the suppression hearing mirrors exactly that. And those are the only 2 references. So everything, the only 2 points that he cited in the order from the deposition transcript are clearly supported by Dr. Hamilton's testimony. One of them, he actually references Dr. Hamilton's testimony for that support. So for that reason, again, any error in referencing the deposition transcript to the extent that the state's arguing that's substantive evidence would be harmless because there's sufficient evidence, as he even points out, from the suppression hearing that supports those same points.
Counsel, the state referenced a case called Dennis. I don't see it cited in the briefs, but do you have any comment on that?
I looked. If I missed it, I apologize, but I'm not aware that they cited it in either of their briefs. Powell stands for the proposition that you can't misrepresent what authority you actually have. Harrison stands for that same proposition. There's a Ninth Circuit case that's also cited in Judge Fleury's order, and they all those cases are citing to U.S. Supreme Court cases of Royer and Bumper. I think it's an accepted principle in law that consent has to be voluntary and consent can be vitiated by an improper apparent show of authority. That's the principle that Judge Fleury relied upon. I don't know what Dennis says in response to that, but I know that the law is consent must be voluntary. It's the state's burden to prove that consent is in fact voluntary. Judge Fleury made factual findings in this case that consent was not voluntary for all the reasons we've discussed, and in particular Dr. Hamilton's testimony. That's a factual finding that this court must give deference to as long as it's supported by consubstantial evidence, and clearly Dr. Hamilton's testimony provides that consubstantial evidence. So I think the state in its brief essentially made 2 points. Number one, the deposition point that we just discussed. The second point was the state said that Judge Fleury got it wrong when he found that consent was not voluntary, but the state in its brief acknowledges that there's contradictory testimony. Unfortunately, that's in essence when you're on that side of of the podium. That's an admission that conflicting testimony means that there must be CSE to support the trial court's ruling. So when they're the appellant, that makes their argument, unfortunately, I believe, impossible, because as long as there is any testimony in the record that would support Judge Fleury's conclusion that consent in this case was not voluntary, appellate courts are required to give deference to that trial court conclusion. So because there is CSE in the record, because Judge Fleury properly applied the law, it is an accepted legal principle that consent can be vitiated by an improper show of authority, and because, as I've argued, I think it's clear that the detective in this case, or the investigator, did not give an accurate statement of the law, contrasted with what was said in Miller, that this court should affirm Judge Fleury's order. Thank you.
Thank you, Counsel.
Can I quote you in our next oral argument, your statement earlier? Thank you for allowing a rebuttal. A couple of things. The citations to Birchfield and Miller, those are implied consent cases. Clearly, there wasn't implied consent in this case. Implied consent was never read, and that was a finding of Judge Fleury, is that it's not an implied consent case. Still not arguing that consent and warrant, or warrant is necessary. My position is, even accepting Judge Fleury's conclusions and, having a basis in the evidence is not the same as having CSE. And, oops, lost my point. Another thing is that an incomplete statement of law is not a wrong statement of law or a misleading or misrepresentation of the law. If he had used the term warrant, we would be here arguing that warrant was a threat and a coercive tactic. Here we don't have a warrant, but the officers readily admit that a warrant was possible. They had probable cause to arrest the appellant. The next thing is that, yes, this court must give deference to the trial court's finding of fact when competent substantial evidence has been presented. I'm calling into question whether there was competent substantial evidence. Those transcripts were never moved into evidence. And merely putting them in the record, while, a smart thing to do, does not enter it into the evidence chain as something the court could rely on. But even so, this court can look at whether Fleury's legal conclusions are supported by the facts that he found. And the state's position is that it's not. The defendant knew he would be able to say no and make the officers go away. He did it once during the first time he was asked. So obviously he knew, but when he is faced with the reality, you're going to be arrested, he did agree to give the blood. He was not coerced into it. He just knew one way or the other. The law said, we're going to take blood. I think the fact that the father reacted so negatively to it, they knew, they were discussing what would happen. I guess I should go into my conclusion because I have 31 seconds left.
You're actually into your rebuttal. You've expired your time, but feel free to conclude.
I'm sorry. I just, based on everything that we've heard in the law, consent or a warrant, we have consent in this case. We ask this court to reverse and remand back to the trial court. Thank you.
Thank you, Counsel. Thank you to those attorneys for your helpful arguments today. The court is now adjourned.
All rise. sure yesterday that we switched that over, so.